Welcome to the Deep Dive. Today, we are taking on a sorts that is focused not just on a tragedy, but really on accountability.
Exactly.
We're looking at the forensic legal analysis from scientific analyst Justin Lake. And it's all about the security failures during the Utah Valley University shooting, the UVU shooting. And this is, it's a crucial analysis because it moves beyond just, simple operational mistakes.
Right. It asks a much, much harder question.
It asks, was this conduct so deficient, so bad, that it actually constitutes gross negligence? And maybe more importantly, is there enough evidence to pursue criminal charges?
And that is the specific high-stakes mission for us today. We're doing a really rigorous exploration using the source material of the legal implications for the security command.
Right.
So we're going to try to set aside the emotional weight of the event itself to do a pure, objective legal dissection of the response.
And the central question, the one that the analyst Justin Lake poses, is really stark. It's not just if they were negligent.
No, it's actionable. It's should a prosecutor charge the command staff? And what specific evidence would you need to sustain those charges under Utah law?
So to answer that, we really have to get into some dense legal concepts. This isn't just about general carelessness.
No, not all.
We're looking at specific Utah statutes, specific case law. Cases that define the very limits of governmental immunity.
Which is a huge hurdle.
A huge hurdle. All to see if the conduct of the UVU Police Department, the UVU PD, and the county command meets that just incredibly demanding threshold for criminal liability.
And the entire analysis, really, it all hinges on one thing: their failure to secure known, explicitly identified elevated positions.
That's the core of it.
It is. So to even determine if criminal liability is possible, we have to start at the beginning. We have to build the foundational case for negligence.
And that always starts with the concept of duty.
Always. In any negligence claim, civil or criminal, you have to begin there. Was there a legal requirement for them to act? And what exactly was the scope of that required action?
Okay, so let's establish this duty of care, because the sources are really clear that this was not some kind of gray area.
Not at all.
The UVU PD, they were the lead agency for event security. They had what the force calls a non-negotiable, defined responsibility to secure those elevated positions.
The rooftops, the upper-level structures, anything overlooking the venue.
So why is that duty considered non-negotiable here?
Well, because it comes from standard professional protective practices. For any rally involving a high-profile political figure, This is Security 101.
You secure the high ground.
You secure the high ground.
Yeah.
It's the most fundamental counter-assassination, counter-sniper measure there is. It's not optional. When you host an event where the crowd and the principal are exposed to overlooks, the duty to control that high ground is, well, it's just inherent to the event itself.
But the analyst points to something much more critical than just standard practice. The duty was actively reinforced by interagency communication. And this seems to be what really cements their responsibility in a way that is, frankly, legally damning. Tell us about that interaction.
This is the detail that really shifts everything. It's what takes it from a theoretical duty to an acknowledged assumed duty.
Okay.
You have Secret Service Chief Brian Harpole. He's representing the Federal Protective Detail, and he explicitly flags the rooftop as a major high-priority vulnerability.
So he sees the risk immediately.
Immediately. And he relays this concern directly to the UVU PD leadership and the county command. He didn't just mention it in passing. He pointed out the specific structural weakness.
And the response from UVU PD leadership.
They assured Harpole the matter was covered.
Covered.
That's the word. And that acceptance, that verbal promise to the primary protective agency legally solidified their role. They became the party responsible for securing that specific location. They voluntarily took ownership of mitigating that risk.
And that voluntary undertaking is the legal linchpin here, isn't it? This is where we get into some of that foundational Utah case law.
Exactly. You look at principles established in cases like Yazd v. Woodside Homes Corps. In Utah, the law establishes duty when a party voluntarily undertakes a responsibility or when a professional standard dictates that they have one.
And here they had both.
They had both. The UVU PD and the sheriff's office accepted operational control for the perimeter and the rooftops, so they were legally bound to do it competently. The analyst argues the duty here is, quote, not even debatable.
Because of that professional standard and the explicit promise.
Right. They promised to cover it.
Which leads us directly into foreseeability. So, okay, they had a duty, but was the risk they were supposed to mitigate a surprise? Could they possibly argue that nobody could have anticipated an attack from a rooftop?
No, absolutely not. The source is emphatic on this point. The risk was universally understood. This wasn't some, obscure threat.
We're talking about an elevated, exposed position overlooking a political rally.
It's what the analyst calls a textbook sniper threat. It's the most common form of deadly outside-in attack planning there is.
And Utah law has a specific measurable standard for this, for foreseeability.
It does.
If we look at the precedent in a case like Bunker v. Union Pacific, the test is pretty straightforward, right? It's just, would a reasonable person in the same circumstances foresee a risk of harm?
And the analyst argues that in this instance, the foreseeability threshold wasn't just met, it was obliterated.
Why so, sir?
Because of the combination of factors. You have a nationally high-profile political figure, you have documented open rooftop access, and most importantly, you have a direct, explicit, documented warning from the Federal Protective Service.
So any argument of surprise is it's off the table.
It's completely gone.
So it's this convergence of factors. A high-value target in an exposed area, federal experts warning about it, and local command saying, yep, we'll handle it.
The analyst calls it the security equivalent of lightning attracts metal rods. The threat wasn't just known, it was actively pointed out. That makes the resulting harm completely predictable if that mitigation fails.
It seems so important to understand the weight of that explicit warning.
It is vital, because if a failure happens that was predictable, but no one specifically warned about it, well, that's just negligence.
Right.
But if a failure occurs, and it is the exact failure that the Secret Service warned about, and it's the one the UVU PD promised to prevent, that moves the needle. It moves it toward extreme deviation and ultimately toward recklessness.
So the foundation is set. Duty is established, foreseeability is established, and both are reinforced by documented interactions.
Absolutely. The groundwork is solid.
So, with duty established and the risk being so foreseeable, now we have to turn to the breach. Did their actions actually live up to that duty?
The source material suggests a failure so profound it can't be dismissed as a simple mistake. Not even close. The analysis moves right to the specific critical omissions. Despite acknowledging the threat, despite accepting the duty, UVU PD's execution it demonstrated a complete breakdown of basic security measures. And the analyst considers that the very definition of a breach.
So what were the specific failures? It wasn't just one small detail they missed, was it?
Oh, no. It was a failure on 3 fundamental counter-sniper protocols. First, they did not post any personnel on the rooftop. No overwatch position at all. None. Second, they didn't block, restrict, or even monitor the access points, even though the approach was a publicly accessible walkway.
So anyone could just walk up?
Anyone. And third, they didn't initiate any active compensatory surveillance. No sweeps, no patrols, nothing. The rooftop, the single most critical identified vulnerability, was left entirely unattended.
The narrative of the event in the source paints a really stark picture of this. The shooter uses a public walkway, gets to the roof, stays there undetected long enough to set up a firing position, and carries out the attack with zero interruption.
It's the absolute antithesis of a secure environment. It's a systemic void.
And the breach, it's made so much worse by the active denial of mitigation strategies.
Yes. This is the element that pushes the conduct far beyond just passive neglect. The Secret Service, they recognized the high ground vulnerability, and they requested drone overwatch, aerial surveillance,
to provide that extra layer of monitoring for those exact areas.
Exactly.
Okay, let's focus on this denial of aerial support, because this feels like a turning point in the legal argument. The source names. It says UVU PD leadership, specifically Sheriff Rice, denied the deployment of those drones.
He did.
So when a lead agency denies a key protective measure offered by the Secret Service, what is the professional expectation that was breached there?
The expectation is simple. When you deny a protective measure, you must immediately substitute a compensatory measure. It's a basic principle. If you can't afford the $100 barrier, you have to post an officer there instead. You have to fill the gap.
But in this case?
In this case, the command structure denied the aerial support and failed to provide any alternate surveillance. No compensatory measure to cover the gap. They denied the drone and left the rooftops completely unsecured, relying on that empty assurance it's covered, which was demonstrably false.
So what's the strongest defense the command could even try to make here?
Yeah.
Could they argue it was a legitimate resource management decision? that they needed those resources somewhere else?
That's the obvious defense, right? The triage argument. We had to make a tough call.
Yeah.
But the analyst just dismisses it forcefully. A legitimate resource constraint decision would mean you accept a lesser risk somewhere to mitigate a greater risk somewhere else. But here, the denial was coupled with that promise that the roof was covered.
So they didn't acknowledge the risk they were creating.
They did the opposite. They accepted the duty, they denied the resource that was offered to them, and then they assigned no alternative resource. That leaves a zero coverage scenario at the point of highest vulnerability. The analyst says that is not resource management, it's operational negligence.
So the breach is measured by this complete departure from what's called the reasonable officer standard. How do Utah courts typically define that in a law enforcement context?
It's defined by what a competent, trained professional would have done in that situation, in that high-risk scenario.
And what would a reasonable officer have done?
A reasonable officer, faced with an explicit Secret Service warning, would have posted overwatch. They would have restricted physical access. They would have conducted repeated, verifiable sweeps. And crucially, if you deny offered aerial surveillance, a reasonable officer must immediately deploy a compensating ground measure.
But the UVU PD and County Command did none of those things.
None of them. And that, according to the source, represents an extreme deviation from expected professional standards.
So it's the extremity of the failure, the total abandonment of the secured area, that gives the gross negligence claim its weight later on.
Absolutely. If there had been, say, a single officer posted who just happened to look the wrong way at the critical moment, that might be ordinary negligence, a mistake. But zero coverage after a direct warning. That's a completely different legal category. It moves the conduct from a mistake to a conscious choice. And that distinction, that extreme nature of the breach, is what lets us confidently move to the third step, proving the failure actually caused the death.
Okay, so we've established the duty and this extreme breach. Now, the analyst has to legally connect those 2 points to the outcome. This is where we apply Utah's two-part causation test.
That's right.
Because if a prosecutor can't prove the breach caused the harm, the entire case just cheaped. It falls apart.
It collapses. And under the Utah standard, which you see articulated in cases like Stephenson v. Smith's Management Corps, you have to satisfy both cause and fact and proximate cause.
They sound similar, but they're really addressing very different legal ideas about responsibility.
Very different.
So let's start with cause and fact, the but-for test. The analyst argues the causal chain here is devastatingly simple.
It is. It's the easiest link in the chain to prove. Cause and fact asks a simple question. But for the breach in rooftop security, would the injury have occurred?
And the answer is just no.
Unequivocally no. But for the lack of personnel, the lack of restrictions, the lack of any surveillance, the shooter could not have accessed the position. They couldn't have remained undetected, set up their weapon, and fired. The operational failure to secure the high ground is the foundational event that enabled the attack.
So if UVD PD personnel had been on that roof, or if access was just restricted and monitored, the shooter gets intercepted.
And the attack, at least as it happened from that elevated position, is prevented. That's but for established cleanly.
Now for the trickier part, proximate cause. This is where we have to consider the foreseeability of the harm itself. Was the resulting death a sufficiently predictable consequence of their negligent conduct?
Right. This requires us to look beyond the immediate action and ask, was the type of harm that occurred reasonably related to the type of negligence committed?
Can you give us an example to differentiate that?
Sure. Let's use a traffic accident scenario. Imagine a traffic cop negligently waves me through a broken signal. That's the cause and fact. But for the cop waving me through, I wouldn't have been in the intersection.
Yeah.
Now, if I get hit by another car, the resulting harm, the collision, is the foreseeable consequence of that initial failure. That's proximate cause. The harm is directly related to the negligence.
Got it. So applying that to the UVU scenario, the failure was leaving the roof unsecured. The harm was an attack from that unsecured roof.
Exactly. There is no external intervening factor. Proximate cause is satisfied because the exact vulnerability the Secret Service warned about, an attacker exploiting unsecured high ground, is the specific risk that materialized.
The source says there is no externalizing factor, no intervening cause.
That's the key line. Had the roof been secured, the harm could not have occurred from that location. The failure that allowed access to the roof is the exact failure that enabled the attack and led to the fatality.
That argument is so powerful because the warning, the breach, and the outcome are just. They're perfectly aligned.
They are.
There's no argument that some other random event disrupted the chain of causation. The command staff's failure was the direct catalyst.
And that unbroken line is essential. It's what allows the analyst to conclude this wasn't some tragic coincidence, but a direct, preventable security failure. So with duty, breach, and direct causation all established, the analysis can now climb that legal ladder from ordinary negligence to the severity required for criminal prosecution.
And this is the critical juncture. I mean, this is everything. Ordinary negligence usually results in civil liability, a lawsuit.
Right. Money.
But gross negligence, that unlocks criminal consequences and it pierces governmental accountability. This is the difference between a lawsuit and potentially serving jail time. So how does Utah law define this extreme level of failure?
For that, we turn to the precedent set in Daniels v. Gamma West brachytherapy. The courts there established extremely high standard. Gross negligence is defined as, and I'm quoting here, the failure to observe even slight care, a reckless disregard of consequences, an extreme departure from the ordinary standard of care.
That phrase, failure to observe even slight care, I mean, that suggests an almost willful blindness to obvious safety requirements.
It does. Let's look at the Daniels case for a second. It involved a serious medical error, a systemic failure to follow basic patient safety checklists and protocols, which led to significant harm.
So it wasn't just one doctor making a mistake.
No. It was an organizational failure to follow widely accepted safety mandates. And the court held that when a professional completely abandons the most basic required steps, failing to observe even slight care, that warrants the gross negligence label.
So we're looking for evidence of reckless indifference, not just clumsiness. The analyst breaks this down into 3 necessary elements for gross negligence, specifically for the UVU command structure. Let's walk through them. Element 1. Knowledge of a significant risk.
That is completely satisfied. The UVU PD leadership and command staff knew the rooftop was critical. They were told directly by Secret Service Chief Hartpole that it was the primary immediate vulnerability. They acknowledged it. They verbally accepted that threat. There is zero doubt they had the knowledge.
Okay. Element 2. Ability and duty to mitigate that risk. Did they have the means to prevent the failure?
Absolutely. They had command of the event site. They had the personnel, the authority, the capacity to secure the roof. They could have assigned 2 officers. They could have restricted access with tape and a sign. They could have used the drone overwatch that was offered to them. The resources were available and the duty was accepted.
And element 3, the most damaging one. A conscious failure to act, which represents an extreme departure.
This is where all their failures converge. They implemented 0 measures to secure the area, not a single one. And it wasn't just that they failed to post officers. They actively rejected an offered solution, the drone, while providing no substitute. The failure was compounded by an affirmative decision to reduce security.
How does that specific action, denying the drone overwatch, connect to the legal term reckless disregard?
Well, reckless disregard implies that the actor was aware of the risk and chose to proceed anyway, ignoring the likely consequence. So the command staff were aware of the rooftop risk. That's element 1. They then consciously chose to deny a specific mitigation tool offered by federal experts, the drones. By denying the drones and then failing to substitute ground personnel, they essentially said, we acknowledge this risk and we choose to leave it unmitigated.
Wow.
The analyst argues that this disregard was so severe that it constitutes an extreme departure and reckless indifference to public safety, easily meeting that gross negligence standard from the Daniels case.
So the gross negligence argument isn't just about the result. It's about the state of mind, the degree of deviation from professional norms. And this finding is the crucial pivot point because it decides whether their governmental shield stays up or comes down.
Correct. If this were found to be only ordinary negligence, they would likely be protected. They'd walk away. But because the analyst shows the conduct meets the high bar of gross negligence, that complete failure to observe even slight care for the most critical vulnerability, the legal landscape changes entirely.
And for law enforcement, this concept of governmental immunity is fundamental. Normally, the Utah Governmental Immunity Act, the UGIA, it's a powerful shield. It protects municipalities and officers from liability for ordinary negligence that happens while they're doing their jobs. Why is that shield generally in place?
It's designed to let law enforcement and other government agencies do dangerous, difficult jobs without the constant threat of lawsuits for every little mistake or error in judgment.
Right, it would grind things to a halt.
It would. If officers knew they could be sued for every operational error, public safety services would just stop. So it's a necessary protection, but And this is a bid, but it's not absolute.
And this is where that finding of gross negligence becomes what you call the statutory silver bullet. The source highlights specific sections of the Utah Code where this immunity is explicitly waived.
Yes, and this is where the text of the law is absolute. You look at Utah Code, Section 63G7202 and Section 63G7301. These statutes state very clearly that immunity is explicitly removed when the conduct involves gross negligence or willful and malicious acts.
So it's a specific carved-out exception.
It is. It's designed for these exact cases of extreme misconduct, which the state legislature decided was unacceptable.
So a prosecutor doesn't have to fight for some new judicial interpretation to get rid of the immunity. They just have to prove the gross negligence standard is met, and the statute does the rest of the work.
Exactly. Gross negligence is one of the very few bright lines the legislature established that automatically strips that immunity shield away from the agency and, critically, from the command staff responsible for the conduct.
And the legal exposure there is immense.
Immense. If a prosecutor establishes gross negligence based on those ignored warnings and the complete lack of security, the standard legal protections are gone. It opens the door not just to massive civil liability, but to criminal charges against the individuals involved.
So the legal assessment has now completed the civil analysis. We have duty, extreme breach, causation, gross negligence, and the removal of immunity.
Check, check, check.
But the source material from Justin Lake pushes further. The primary focus here really is the criminal implication.
That's right. And this is where the stakes just increase exponentially. We move from the government potentially paying damages to individuals facing potential felony convictions. And the burden of proof for criminal liability is much, much higher. It's beyond a reasonable doubt.
Which requires an even more rigorous examination of the evidence and the specific statutes.
Absolutely.
So the analyst explicitly assesses the potential for criminal charges against the high-ranking command staff and supervisory officers, the people responsible for planning and operational decisions. This is an uncomfortable but necessary conversation to have, charging law enforcement leaders with crimes related to operational failure.
And that political reality is exactly why the evidence has to be impeccable. The analyst focuses on two specific Utah criminal statutes related to causing death through operational failure. The first one is criminal negligent homicide under Utah Code Section 765206.
What exactly does that statute require in terms of mental state and conduct?
Okay, so criminal negligent homicide requires causing the death of another person by acting with criminal negligence. And the statute defines criminal negligence as a gross deviation from the standard of care that a reasonable, ordinary person, or in this context, a reasonable officer, would exercise.
Right.
And critically, it focuses on failing to perceive a substantial and unjustifiable risk that should have been obvious.
So given the evidence we've talked about, the explicit warning from the Secret Service, the complete abandonment of the rooftop, is that gross deviation element met?
The analysis finds this charge to be highly sustainable. The UVU PD's failures constitute a severe, shocking departure from expected police protective practices. The risk was substantial, it was obvious, it was explicitly flagged. The command staff's decisions or their omissions were the direct cause.
So the deviation is so gross it warrants criminal sanction.
That's the argument. The evidence is there to prove they failed to perceive the risk in any meaningful way, despite being spoon-fed the details of that exact risk.
Now, let's look at the heavier charge. Manslaughter by criminal negligence under Utah Code Section 76-5205. This one carries a higher penalty and requires proving an even more culpable mental state. What is the precise difference between these two offenses?
This is the critical legal nuance you need to understand. Criminal negligent homicide focuses on the failure to perceive an obvious risk, a gross deviation. Manslaughter, on the other hand, focuses on reckless conduct.
Meaning
the actor was aware of the substantial risk and consciously disregarded it.
Oh, wow. Okay. So if the command staff truly failed to realize how severe the risk was, that's negligent homicide.
Right.
And if they knew, they acknowledged it, and they proceeded anyway, it's manslaughter. That denial of the drone support seems crucial here.
It is the defining piece of evidence for the manslaughter charge. The analyst argues a credible case exists for manslaughter because the command staff were explicitly warned. They verbally acknowledged the threat to the Secret Service, and they still made the active, conscious choice to deny offered resources and then fail to allocate any substitutes.
So this isn't a passive failure to perceive.
No. This looks like an active, conscious disregard of a known lethal hazard.
So that evidence trail, the documented verbal assurance to Secret Service, followed by the specific denial of resources. That's the key to moving the culpability from gross deviation to conscious disregard.
Precisely. It suggests an unacceptable prioritization or, frankly, an indifference to a matter of life and death.
Which is what a prosecutor would argue.
That's exactly what they would argue, that they had actual documented knowledge of the risk, and their decision to ground the surveillance assets and leave the roof unsecured was a reckless choice that created a substantial and unjustifiable risk of death, which ultimately materialized.
Finally, the analysis needs to target specific individuals in the chain of command. How does liability even attach when you're dealing with large agencies and these big operational decisions?
Liability attaches to the specific roles responsible for planning, for authorization, and for real-time operational decisions. So this would include the chief of the UVU PD, the event incident commander, and any supervisors who were tasked with or who signed off on the security assignments for the buildings and rooftops.
The analyst recommends convening a grand jury to proceed. For you listening, what is the practical purpose of that step in a case like this, one involving high-ranking public officials?
It's purely evidentiary and to some extent political. To prove who consciously disregarded the risk, a prosecutor needs to see the internal communications.
Things they wouldn't just hand over.
Exactly. A grand jury is necessary to compel the production of sensitive materials that would otherwise be shielded by interagency courtesy or privilege. They need the unedited radio logs. They need the planning memos detailing that drone denial request. They need the resource allocation spreadsheets and the sign-off sheets for the security assignments.
So the grand jury provides the legal muscle.
It provides the necessary legal muscle to establish exactly who was responsible for grounding the assets and who affirmed the threat was covered when it clearly, tragically, was not.
So this entire process, then, it highlights the viability of a criminal prosecution. It confirms that the legal framework exists in Utah to pierce that governmental immunity and pursue these charges, provided the investigative details align with that high burden of proof.
It shows the pathway to accountability is viable, but it would require a relentless investigation to trace that decision-making process all the way from the moment of the Secret Service warning to the moment the security plan failed to deploy. The analyst's work here provides the legal roadmap for that investigation.
This deep dive into Justin Lake's legal analysis has been, it's been rigorous, but the conclusion is really unambiguous.
Yeah.
The case for gross negligence against the command staff is built on 3 pillars. Accepted responsibility for a critical threat, explicit and repeated warnings from federal protective agents, and an extreme breach defined by that active denial of offered mitigation, the rejection of aerial support, without providing any substitution.
And that failure creates a direct, unbroken causal link to the fatal outcome.
In final synthesis, the UVU shooting was, according to this source, a direct result of a preventable security failure.
That's the bottom line. The evidence, when you analyze it under Utah case law, meets every single criterion for gross negligence. And that legal finding is the statutory key. It's what strips away governmental immunity and justifies potential criminal charges, specifically manslaughter by criminal negligence against those in command.
The failure wasn't one of confusion, it was one of choice. The bar for criminal liability is immense, especially when you're charging high-ranking law enforcement. But that combination of documented explicit knowledge of the threat and the active unilateral decision to reduce security measures, that appears to be what pushes the conduct over the threshold. It goes from tragic incompetence into the realm of criminal recklessness.
Indeed. The systemic failure here wasn't just passive neglect. It was the active denial of the drone surveillance, combined with a subsequent failure to mitigate the massive risk created by that denial. When professionals knowingly ignore critical, explicitly flagged hazards, the legal framework provides a pathway to accountability that targets command responsibility.
So we'll leave you with this final provocative thought. We often accept operational mistakes as part of the unavoidable risk of large-scale event management. But when the decision-makers actively reject necessary security measures, moving beyond gross deviation and into what the law calls conscious disregard of human safety, does this focused application of criminal law fundamentally change how you view command responsibility in these high-stakes public safety roles?